Welcome to Law Sessions. I am Jennifer Housen. In this session, we will consider co-ownership in this second lecture of co-ownership. In a previous lecture, we considered severance, but the entirety of this lecture will consider truss, and in particular, we will focus on the majority of the cases which in recent times have looked at the matrimonial home. Now, land law exams generally have two questions in relation to co-ownership. One relating to severance, which is already discussed in another lecture, and the other will usually look at truss in relation to the matrimonial or family home. Wherever there is not one person of full age and capacity entitled to the whole estate in law and equity, then you will see that there may very well be a trust. So, for example, co-ownership of a legal estate is generally straightforward. There will necessarily, of course, be co-ownership of the legal estate where and only where the legal estate is vested formally, inter vivos, meaning whilst you're alive, or on death in two or more persons. In the case of a registered title, the vesting will have to be completed by registration of the co-owners as the new proprietors. There cannot be more than 4 co-owners of the legal estate, and they will, of course, usually be joint tenants at law rather than tenants in common. A legal joint tenant cannot be severed. That is, it cannot be converted into a legal tenancy in common, as there is no such thing. Of course, the lecture on severance has dealt with this in detail. For co-ownership, there must be at least one other person in the landowning relationship. So, if there are 2 legal owners and 1 beneficial owner, if there's 1 legal owner and 2 beneficial owners, or 2 legal owners and 2 beneficial owners, this will amount to a co-ownership situation. If you're only looking at a situation where one person legally owns and is solely beneficially entitled to the property, then no trust situation arises, as the legal ownership in that situation does not separate from the beneficial interests. So wherever there is a joint tenancy of the legal estate, there will, of course, be a trust for those entitled in equity. Even in the common case where 2 joint tenants hold in trust for themselves as joint tenants or tenants in common, you are looking at a trust situation. What about ownership in equity, where a person is claiming the whole or a share of the ownership in equity, meaning an equitable beneficial interest? You may need to ask the following questions and ask them in this order. Does the claimant have an equitable interest? Meaning, is there a share in the ownership in equity? In other words, has a trust arisen in that person's favor? Second, if a trust arises, what is the nature of that interest and what is the size of the interest? If it is that the person has a share as an equitable co-owner, is it that it is as a joint tenant or a tenant in common? Now, that sort of question you could not ask in a legal co-ownership situation because tenants in common doesn't operate. And if as tenant in common, what is the size of the share? The other question, of course, is, having identified the interest, you may want to consider whether that interest is binding on a subsequent purchaser or anybody else claiming an interest in the land. Now, a trust of land can arise in any number of ways. It can arise by formal express declaration of trust, where it is imposed under the LPA 1925 to deal with the operation of overreaching. It may also arise informally in the absence of an effective express declaration of trust. So a trust may be created informally in any one of the following ways. For example, impliedly by way of a resulting trust, or by a constructive trust. Also, it may arise by proprietary estoppel. We will consider the first two briefly and spend the rest of the session focusing on the third, as this is where the meat of land law exam in this area arises. So of course, we will consider the whole aspect of resulting and constructive trust and certainly proprietary estoppel in some detail, but let's look at the way the trust arises, for example, in the first two scenarios. The first is that there is a formal express declaration of a trust. It is worth remembering that this is the way in which the vast majority of trusts of land will arise, though the least likely, of course, to appear on an exam, because it doesn't have that feel to test you and to stretch you. So, of course, an express declaration will always be the most obvious. If an examiner therefore tells you that there is an express declaration, take it as a gift, because it means you need to focus not on the actual declaration itself or whether there was a trust expressly created. You need to focus on other aspects of the question. The second, of course, is a trust imposed by statute. There will be a trust of land wherever the legal estate is not held by one adult person of sound mind for her own sole benefit in equity. There is no escaping this principle, and so to make the system work, the 1925 legislation contains rules which impose a trust, meaning a statutory trust of land, wherever it is required but has not otherwise been created either expressly or under the rules of equity. So, for example, a resulting trust. So where equitable beneficial interests are created expressly without any accompanying express creation of a trust, the legislation will impose a trust automatically. We now, of course, come to the most important aspect of this area, important no less for land law examination purposes, the informal creation of trusts, resulting trusts, and constructive trusts. And what we will do after the break is to discuss this in some depth in order for you to understand this area, and we will also focus on cases relating to the matrimonial home.